comes back.
Hello?
Are you ready, everybody? All right, listen. William Ingram, cover your butt. Set.
A lovely good afternoon to you. Another Saturday is here with us on the Community and the Law. My name is Ureku Owusu-Frimpong, and we're live on BWTV, BWF Solicitors Facebook, BWF Solicitors YouTube, and all the social media platforms. Now, when we meet on a Saturday afternoon like that, we bring you something to discuss. And what we're discussing today is very critical and important to you as a spouse of somebody who resides here in the UK. Spouse Visa Financial Requirements and Exemptions. How to meet the financial requirements. Ladies and gentlemen, it's the Community and the Law. Next.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Yes, welcome back and thank you for joining us. This is the start of that wonderful journey we're going to have this afternoon. For 2 hours, we're going to have a very lovely discussion, something that will be of benefit to you. But in the meantime, and first of all, let me say welcome to a new month, March. We have gone through January, we've gone through February, and March is here with us. March is deemed as Ghana month. So within the month of March, we will be giving you bits and pieces of what Ghana price itself off. And we'll be inviting you to come to BWF Solicitors, visit our offices, and you will enjoy that wonderful bite that we call King Bite, a very natural chocolate from Ghana. BWF Solicitors is on the fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters, North London. Call them Monday to Friday between 9:30 in the morning and 6 o'clock in the evening on 0208 493 7340 or 077 127 61884. BWF Solicitors, we thank you for being our benefactor and always allowing us to come into the community to educate ourselves and also empower ourselves to be able to stand at the right-hand side of the law and not fall foul to it. This afternoon, the community and the law is bringing you one very interesting topic, and we're going to look at spousal visa financial requirements and exemptions, how to meet those financial requirements. We'll be taking you through steps and also to be giving you updates as we go on. Once again, my name is Owusu Frimpong. Let's get into this together. Welcome back, and thank you for still sticking around. Now, if you have found it necessary to stay on up to this point, I would ask you to do something for me. Go to the comment section and click on the like button, and also click on the notification bell so that whatever we put out there, you will be a part of it. This afternoon, I have the privilege and honor to be hosting the senior partner of BWF Solicitors, Mr. Bernardo Owusu. Uncle Ben, we call him, and he's going to lead us in that discussion where we'll be looking at those financial requirements, the exemptions that there are, and of course, we will also be looking at how we can put in our application and do it right. So please stick and stay with us. But first of all, join me as we say hello. And even though we are at his premises, we'll be welcoming him to BWTV. Uncle Ben, good afternoon. Thank you for joining us.
Good afternoon, Kweku, and good afternoon, Adai. It's always a pleasure to be here with all of you.
We welcome you too much. And I have dared to ask people to visit BWF Solicitors. You work between Monday and Friday, 9:30 and 6 p.m. for them to come taste Ghana and look at or even feel the hospitality that the Ghanaian is proud of. So be rest assured that people will be climbing up to the fourth floor of the Ghana House. Thank you very much for coming. Well, as I said, we're going to look at spousal visa financial requirements and exemptions, how to meet those requirements. And we'll be looking at things that you need to know, things that you need to put in place, and how you make your applications. But before then, as tradition demands, BWF Solicitors Monday and Tuesday, Wednesday, any updates that would have come in the situation, they would have put that one out. Let's start with the nuggets that we have. Care and senior care workers, that is the SOC 6145 and 6146, can still bring their dependent family members to the UK after March 10, 2024, if they are already in the UK or have applied under the route for leave by March 10, 2024. This is from the Statement of Changes in Immigration Rules, HC 556, dated the 19th of February, 2024. If you were with us on the program last week, we really took our time to go into that. Uncle Ben took us through what the new statement is, what the new changes are, why it is that we say that care and senior care workers on the SOC 6145 and 6146 can bring their dependent family members to the UK after March 10, because the rule now is after March 10, care workers cannot. But then we had the opportunity of going through that. Later on, when we finished, somebody was like, "Well, that's a good lesson on the interpretation of the law." Yes, that is what you get from BWF solicitors. BWF solicitors are trusted partners when it comes to the law. I'll be asking Nkaben to help us with this explanation, but there's one thing that BWF solicitors does so very well. And today I would want us to witness and acknowledge one of that and congratulate our dear sister Deborah Adu for qualifying as a solicitor to the Senior Courts of England and Wales. Congratulations, Debbie. And I want to say once again to Uncle Ben, thank you for allowing people to learn from you, allowing people to express themselves and also to find themselves. So, this is our young lady. Tell us about her. From the picture, she's very quite young, qualified as a lawyer, and I know it's one proud feather in your cap. Tell us about her, Uncle Ben.
Well, once again, the community benefits from all this progression, and it's a progression that I have made in my business. I think 2 years ago, when we had our celebration, I did promise that I'll make sure that on my part, I will create as many lawyers as possible for the community. And that's what we've been doing. I think that's my legacy. Deborah, very young lady. She only turned 25 recently. So, I mean, when I qualified as a lawyer, I was 27. She's 25. So clearly she's done something right. The average age to qualify as a lawyer in the UK, from university, you do either 1 year or 2 years law school. So that's at 23, 24. And then you do 2 years on your training. That will take you to up to 25, 26. So, she's just about done the minimum that you can do. She's one of our intelligent lawyers, very young. She's picked up rapidly. The training is very rigorous, and clearly for some of them, it's a big beginning of a very difficult experience. Used to living with their mom and dad. She travels in a typical day in and out about 5 hours or more.
Wow.
to get here, to come and learn and to be able to serve the community. She's a very pleasant person, and the comments that I've received over the last week from her peers in the house is that in the last few months, she's grown really well. She's become extremely beautiful and very, very intelligent. Not that she wasn't intelligent, but she's become even more intelligent.
That's right. Yeah.
Over the last few months. And you can see the confidence exude from her. And for us, that is part of the training. I mean, the number of people that I've had come through me who could barely hold a conversation, even between two people, can now go out and speak to potentially thousands of people. She's one of those who is very confident, has always been confident, but she's even more confident now because of where she is.
Well, Debbie, once again, I want to say congratulations to you. I bear testament to the fact that, yes, the first time I saw her, she was a bit quiet and all that. But now I know that smile you have in the picture tells me that, as Uncle Ben has said, you've grown more in confidence. And we look forward to seeing you on our program. And that one, I know Uncle Ben will push you to do that as well, so that you can also represent the organization and help the community. Congratulations to you. Now, back to the nugget. Care and senior care workers and the ability to bring in their dependents. Uncle Ben, last week we did that, but maybe a recap of that so we can reinforce that knowledge.
Okay, so as you know, December, the Conservatives, as usual, when election is approaching, they throw red meat to their followers just to excite them. And as part of the process, they mentioned that they were going to reduce net migration by some 300,000 plus. And, 5 points that they laid out included, banning care workers from bringing their dependents and amongst other things. So this is one of those areas. We were not too sure what they were going to do. The first statement that came out in October was basically that they will ban care workers from bringing their dependents.
Yeah.
There was no exception. And then they gave a statement, which is the Minister for Immigration, gave a statement in Parliament, and he also elaborated a 5-point, and he also mentioned that care workers will be banned from bringing their dependents. So when the law came out, almost every lawyer said care workers cannot bring their dependents.
Yeah.
And then, I went back and took the law. It's a very difficult law to read, and then you have to put it side by side with 2 other legislations. So you read 3 legislations. The Statement of Changes, which is the current one dated the 17th of February, HC 556, and then you look at Appendix SW, which is a current skilled worker route, and then Appendix CHI, which is a skilled worker children route. And then when you combine them, you see that we did the exception under the unless. There is an unless, which is perched in front of P. Unless P, and then P we know is the parent or the partner in this case, and therefore she's a sponsor. And then because unless comes before her, anything that comes after the unless is a qualification that is in her favor. And it says that unless P is already on the route, has made an application on the route, so that we know if she's already or he is already on the route or has made an application, then the unless takes her out of the ban. So it's not all of them who are banned. And we are very grateful that the government does realize that for those people who were lured to come here, they were told that they could come with their family members. And that's why some of them came. We estimate that about 30 to 40% of people will not come because of this particular factor. Currently, there is some delay on issuing of DCOS, which is a defined certificate of sponsorship for all areas of sponsored migrants route. And we believe that it's because of the ban that is coming on the 11th of March, because they want to hold on to the numbers so that people don't rush to bring their dependents or make applications. There's one thing that I've noticed, which is of concern to me, and I've mentioned it. I'm taking steps to see what we can do about it, because the statutory provisions and the statutory remedy that is available, usually to our mothers and sisters and daughters and nieces, is not adequate to address the situation. I mean, the law allows you to bring your child, but when you're bringing your child and the other parent of the child is not already here or coming with the child or coming later, then it becomes difficult to bring the child, and mostly will be that they refuse them. As a decision I received from a new client yesterday, and it tore my heart. We have decided we will also play the game with them. So already started. We will speak maybe off camera to our clients and people who contact us, and we will also play, because totally is not fair. If administrative review is taken up to a year, and the administrative review doesn't look at the merits of the case, but whether or not there's been an omission, therefore that does not address, even if they refuse your child to join you and you use the administrative review route, it doesn't address the problem, because 90% of administrative review for children are rejected. They then lure you to take permission from the child's other parent. And then when you take the permission, and this is what really tears my heart, when they lure you to take permission from the other parent,
then they give you the reason that if the parent is available
and give him permission, it means they are the
child's life.
So the child cannot come. So why do they ask you? So just before we have a full-blown discussion, I think I will do a video next week. Please, when you're applying as a skilled worker or a parent to bring your child to the UK, and you are the only parent here and the other parent is alive but not coming with a child, never take consent, permission, authority from them. Never. And never. We've said this before. I've done a video. I think I've done a video on this before. But I will put a lot of emphasis on skilled workers and how they can overcome this particular rather unfortunate request from the Home Office.
Yeah, you don't get this from anywhere else, but on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. Call them on 0208-493-7345. Well, that's the studio number, is 7340. I should say 0208-493-7340 or 077-127-61884. Now, Uncle Ben, whilst we're on this one, I think there have been some dates that have been thrown in that indicate that changes are coming. The first one we were looking at is the 11th of March 2024, which you have alluded to now. There are other dates that are coming up that we need to take note of. What are these?
Well, so we've put together, it's actually 5, but I've intentionally set it to 4 because the 5th one is a bit technical, and the 5th one is tied to the first one. So at least we know it's 11. They are both 11. So the first one, we know 11th of March, all new care workers who are now making applications to go on 6145 or 6146, which is Standard Occupation Code for care worker and senior care worker, cannot bring their dependents after the 11th. This is for new care workers, not those who are already on the route.
Okay.
Then on the 4th of April, the skilled worker minimum salary is increasing from the current rate of 26,200 to 38,700. That is a whopper. It's a whopping increase. And it affects a lot of the areas that are not on skilled shortage occupation list. So shortage occupation list is SOL. So that is not on the list. Then we have the same 4th of April or thereabout, plasterers who are also called dry liners and jointers. They will be removed from the shortage occupation. That is a recommendation.
Now, is this part of the construction bit?
Yes.
Okay.
It is. So plasterers, when you look at the code, is 5134. I think I'm right. Oh, memory. 5134. That's for plasterers, jointers, joiners, dry liners. They all come under plasterers. I've got some clients who are plasterers, and they will be removed from the shortage occupation. It doesn't mean that they cannot bring anyone. It means that a 38.7 will catch them. For every person on occupation list, you get 20% off. Okay. Sometimes 70% off if you're under 26 or you've got a PhD. But you get 20% off, and that is why instead of £12 something, their pay is £10.75. So they will pay the 38,700, but it will only affect those who haven't already gone on the route. And then almighty 11th of April, 2 days to my birthday. What a gift. All spouses under FM route and Her Majesty the military route. So people who are coming here as fiancés, as unmarried partners, as common customary law wives and husbands. Your husband, your wife, your employer should be earning £29,000 a year with policy in to increase it. But I know Labour will win this election, and I don't think the rest will follow. But this is starting on the 11th. I don't think we'll have an elections before the 11th. Well, I think
the elections is in May. So.
Have they called it now? But the earliest they can.
The earliest can have it is in May.
Okay. So this is something that I think we're putting a lot of emphasis on today. So these are dates that I want you to keep. We will share a flyer on it on Monday. But if you can also take a picture of this and share so that people are aware, because it can be confusing.
Okay. So the dates, as Uncle Ben has put it, we have the 11th of March, the 4th of April, and the 11th of April. So if you forget about anything at all, Remember, the 4th of April, skilled workers' minimum salary is increasing to £38,700, and plasterers will be removed from shortage occupation from the 4th of April 2024. And as Uncle Ben mentioned, it doesn't mean that you can't bring your partners, but the 38,700 caveat will catch you. Then on the 11th of April 2024, spouse or partner visa minimum income is going up to £29,000. So that's by way of updates and nuggets, and we will be getting into the discussion. Now, if you would want to join us on the program later on with your question or concern, don't do it now. We're going to have our discussion, but you can call on 0208 493 7345. 0208 493 7345, or you send a text to 07399 208 468, 07399 208 468, or send a WhatsApp message or voice note to 07950 422 780. We have with us as a resource person, a senior partner, a benefactor, and of course, the main person behind this whole dream, Mr. Bernardo, so Uncle Ben will call him, and he's going to lead us in the discussion on spouse visa financial requirements, what the exceptions are, and what to do to meet them. BWF solicitors, we want to say thank you very much. We'll play the message, and we want to get people to be using their services because you are assured of between 95 and 99% success. If it will work, they will tell you. If it will not, they will advise you and look at other strategies that will help you succeed. That's BWF solicitors. That's the assurance. And that is the quality I am talking about. We'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340, or our emergency line 07712 761 884.
Thank you very much for sticking around. Those of you on the platform, yes, when you come on there, please announce yourself and greet your competitors on there. I call that the classroom. Make it exciting, get the discussions going on there, and let's follow what we're going to bring you. Spouse visa financial requirement and exemptions, how to meet the financial requirements is what we're going to look at. So keep your tests coming through, keep them on the comment section, either on Facebook, YouTube, BWF Solicitors on Facebook, BWF Solicitors on YouTube, BWTV on Facebook and YouTube as well. Then those of you who are sharing, I will be giving you the statistics we had in February. I think I've got that, and I'll be sharing that with you. That will show you who is leading the pack, and we'll be going on like that till the end of the year, December 2024. Now, without wasting much time, let's go to the knowledge desk, so to speak, where the senior partner is seated and ready. Uncle Ben, the financial requirement for spousal visa, what do we have to meet and look for?
Okay, so before I start with particular details of what we have to meet and what we look for, I just want people to understand that this is a requirement specifically to spouses and children who are joining their parents who are spouses.
Okay.
And also people who are joining their parents or spouses who are in the army. So it's just this limited area. It doesn't apply to everybody.
All right.
So if you're a fiance, an unmarried partner, a partner of a soldier, of somebody who is a British citizen settled, or an EU national who's got limited leave or indefinite leave to remain, or you are a child who's joining a parent who is coming or already here as a spouse of another person. That is when this rule will apply. Already there's been a court challenge in February of 2017 when the case of Lebanon went to the Supreme Court on the basis that this particular requirement, raising the income requirement to 18,600, was going to disenfranchise a lot of people from bringing their families. The Supreme Court looked at the case and found that it was not discriminatory and that it was not against Article 8 of the European Convention on Human Rights. And however, they said that they want the Home Office to also add that in situations where particular families cannot afford to bring their families, but then there are particular circumstances that makes their situation dire in the sense that if they are not allowed to come, it will breach the convention. The Home Office should allow them. As a result, in August of 2017, the Home Office amended their rules and added what we now call GEN 3.1, which is that if you don't have the 18.6, but there's something in your life or there's support from somebody, the UAE don't allow third-party support, but there's genuine support available, then you can rely on that. Also, we've always had an exception to the rule, which is that people who are claiming certain particular benefits, including disability, living allowance, carers allowance, police disability allowance, military disability allowance, widows disablement allowance, a lot of allowances obviously are also exempt, but that would take you from the 18.6 to what we call adequacy of maintenance. Very technical. So what you have to do is you need to look at what we call the eligibility requirement and the flexibility requirement. When we look at the eligibility requirement, the eligibility requirements are that in addition to being in a genuine relationship, having met the person should be earning at a rate of 18,600, and as part of the specified evidence rules, you need to provide 6 months pay slips, 6 months bank statement, employer's letter, your last P60. If you're self-employed, your last full year's self-assessment, and SA 302, which is a calculation by the HN revenue, which tells you your gross income, net income, and how they've applied the tax, and proof of ongoing work. So for those who are self-employed and those who are employed, you are all required to show evidence of income.
Okay.
Then within the rules, there's something that we call the permitted source of income, the permitted source of funds. There are there's A, B, C, D, E, F, G, H. That is 8.
8 of them.
8 sources. The first 2 sources are related to employment income. So the employment income, there's the salaried income and the non-salaried income. Please, it's very technical and complex. I will just broach the subject and not open it too much, because if you allow me, I will talk like a lecturer. And we're not going to leave here today. So if you're earning income, you're employed, you are either on a category A or a category B. I'm not going to explain. One is called salaried income, one is non-salaried. I think I will give you this. The salaried income are for those who have a fixed income. So you say you're earning 30,000 a year and that's all you earn. And there are people who are paid by the hour. So their wages go up weekly or monthly. It goes up and down. Those are the non-salaried. And then we have the category C. I've talked about A and B. A and B are employed income. And then the C is non-employed income. Non-employed income can be from savings. It can be from rental income. It can be from stocks and shares and debentures. What's a debenture? It's a technical word. It means stocks and shares. It's another type of
the investment you've made.
That's correct.
Yeah.
So if your income is coming from there or from property, please. I'm not saying Airbnb. There's a reason why I haven't said Airbnb, because if you're living in that property and the income is coming from that property, you cannot use it as part of your income. But any income that comes from property is called property income, and that will be category C.
Okay.
Then the category D is what we call savings. So any savings that you've had, we know that if you are on the 18-6, you need a starting savings of 16,000 plus the shortfall. If the shortfall is 5,000, it's 5,000 times 2.5 years. If it's 18-6, it's 18-6 times 2.5 years, and you're supposed to get about 62 or 64,000 a year. When it goes up on the 11th of April, the savings you need is 82,000, not 64 anymore. 82. You start with a basic of 16, because 16,000 is the savings that prevents you from claiming benefit.
Okay.
So if you have savings of 16,000, you cannot claim any benefit.
That's right. Yeah.
Yes. So 16 plus the shortfall or the full amount times 2.5 years. So I've done A, B, C, and D. We go to E.
That's the fifth one.
Yes. The E is what we call the pension income. So if somebody is earning income through pension and some other things, then again, you can have that. The other one which I talked about, the non-employed income, includes alimony, child maintenance, academic maintenance. So people who are going to school, who are getting maintenance. Again, if it's academic maintenance, you can use that. So now A, B, C, D, E. We now have to do F. Okay. So the F also is a type of income that usually we call, the G and the H is a type of income that we call the self-employment income. So the self-employment income, the G is for people who are using 1 year, and the H is for people who are combining 2 years. Some of this you can combine, others you cannot combine. The A, B, C, D, and E, you can combine.
Okay.
You can combine self-employment with employment income.
Okay.
That is the only ones you can combine, but they have to be to the same time. Now, remember that when I started, I said your self-employed income must be for the last accounting year. The last accounting year for UK will be, I think, the 4th of April.
Yeah, so the 31st, the 4th of April last year to the 31st of March, or the 4th of April this year.
Yes, so if you're making your application now, because we are not in April, you will use the 2022-2023 account. So you will use April 2022 to March 2023, and the account was filed January this year. So if you're making your application now, you cannot tell the Home Office that, oh, I haven't filed my account, because you should have filed
by the end of January. Yeah.
That is the income. If that income is short, you can add 2 years. So for example, if you've got 30,000 last year, but this year you got 18,000. So the 18,000 is short of 600. But when you combine the 30,000 plus the 18,000 and you divide by 2, it will give you more than 18,000. And that's what we called the G and the H. That last one is a H.
Okay.
So these are the permitted source of income.
Now, and just before you go, you said that some you can combine.
Yeah.
Can I combine 1, 2, 3 or A, B, C together?
Yeah.
Or I can pick one and another of another category, just that?
Okay. So if you've got a savings, you can combine with income.
Okay.
So let's say you're earning 18,000. You're not earning 18,600, so you're short of £600, and you've got a savings of, let's say, 20,000. So you start with 16,000, and then the 600 you multiply by 2.5, which will be 1,002 plus half will be 300, 1,500, and you add that to the 16,000 that'll be 17,500. That's all you need to show. You add that to your income, you've got it. So if anytime you're adding the savings, it has to be the shortfall of the income plus 16,000, multiply the shortfall by 2.5 years. That is how you can add it. Your unemployed, your self-employed income must always be for the last tax year. And you need an SA 302, you need your bank statement for 12 months, you need your accounts, the self-assessment form, or the SA 302 is one sheet of paper, which the Inland Revenue gives you when you file your tax online. It is a sheet that comes, it tells you how much tax you have to pay. This is not a complete SA, which is a self-assessment forms. You need that. You also need evidence of ongoing business because you're using 1 year account. So between 2022 and 2024, they want to see what you're doing. So they want to see ongoing business. So still receiving money into your account, maybe paying your tax. You still got a lease to your address, or if you're using your home address, that's fine. And then you have those evidence and then you provide it.
Okay. So what would be the age? The last one, if you would want to reiterate, the age.
The age.
The age. We've gone A, B, C, D. The eighth one, that's the final bit.
Okay,
just
so we've got A and B are employed income. C is non-employed income, which is savings.
Yeah.
And then D is
the pension.
non-employed income. Non-employed income, which is money from investment and all of that.
Okay.
So that's a C.
Those returns from investment.
Yeah, the D is a savings. The
E.
You've confused.
Okay, no worries. We'll come back to that. What I wanted to really reiterate was that we have 8 of them.
Yes.
And the situation you can find yourself in is where you do not have to. You know where to combine and what not to combine, and with that, we'll come back to that.
Okay.
Then, moving the discussion on. Sorry about that. Moving the discussion on. It's a bit technical. So, to the ordinary person like my good self, who does not understand these things, the accountants may be able to understand. Lawyers, you may be able to understand. How do I? Well, obviously, the answer will be go to the lawyer. But how do I determine that I am able to get these ones? Is it from my bank statements? Is it from my pay slips? Is it from letters I'll get from the HMRC or what? Okay,
so if you're using your savings, then it has to be savings from an approved bank by the FCA, which is a financial whatever authority. The bank will have to provide you with a bank statement or your balance on their headed paper.
Okay.
You can print online bank statement. That's allowed. Before they didn't allow that. If it's income from employed source, it will be your pay slips,
okay,
and a letter from your employer, which will confirm your level of income.
Do the two have to come together?
Yes.
Okay.
Yes. I mean, the word uses maybe a letter from the employer. But when you look at it, it's discretionary. But when you go further, it's mandatory. And that's what I've never understood. So we've always asked for it.
Okay.
And then your last P60. It's not everybody who will have a P60. Because if you've worked for 1 year, you've worked for 1 year, it's possible that within that 1 year, you didn't get a P60. So P60 again, although is recommended, is not mandatory because the P60 gives a historical record. It doesn't give the current record. Your last 6 months is the 6 months before the application.
Okay.
So if you're making the application in March, it will be the last 6 months payslip from February going back. For employed income, we know. The other bits in relation to savings, the money should have sat in your savings account for at least 6 months.
Okay.
Please don't confuse that with what we call the adequate maintenance requirement. I've seen a decision that I was preparing a skeleton argument, And the immigration officer didn't understand the difference between adequate maintenance and a maintenance which is prescribed by either Appendix FM or the specified evidence Appendix SE. These are prescribed stuff. So they tell you we need 6 months. So once they say we need 6 months, you have to provide it 6 months. I just want people to also know that even if you don't earn that money, you can still bring your family member. You have to then situate yourself within what we define as the general exemption, which is GEN 3.1, which obviously is an escape route for people who cannot meet the financial requirement. And some of the things that they look at is they look at Section 55 of the Borders Act, which if there is an interest about a child, particularly his welfare, health, education, and maybe separation. Now, there's a document that I wish to refer to, which we'll show online. And that document was prepared by a group of lawyers and academicians. When you look at this document, family migration rules, spouse and partner migration rules, an initial finding report examining the mental health impact of the rules. I intentionally brought this because it's looking at the mental health. Now, if you can use this report to say that if you don't allow my husband to come, he will fall within this. Let's go to page 6 of that report. Look at that. These are the key findings. The requirement creates single parent families and impose a very high economic, social, and emotional burden on all affected families.
Right.
The effect is discriminatory because it is felt disproportionately by women, young people, and those living outside of London or the Southeast, and working single parents, usually mothers. The overall effect makes it harder rather than easier for mixed nationality families to integrate into the society. Remember that some of the reasons for introducing this was to help people to integrate into the society. British citizens and settled residents are very badly affected by these rules, with significant impact on the mental health and well-being of the British citizen. Kwaku, look at this. Let's go through. 92% of those surveyed said that their children's mental health suffered as a result of the separation. Look at what they went through. Night terrors, sleep issues, crying at night, school and education impacted, impact on confidence and self-esteem, identity issues, worry, confusion, misbehaving, lashing out, violence, anger, withdrawal, crying, suicidal ideation, self-harm, separation anxiety, attachment disorder, depression, attention deficit, whatever it's called, selective mutism. So somebody who cuts themselves, stool holding, eating disorder, loss of hope, loneliness. Now, if this does not meet Article 8, I don't know what else will meet.
Yeah, and there are serious ones in there.
Very serious.
Very serious ones in there. Because if you look at something like suicidal ideation, that's terrible.
Yeah. And these are children.
Yeah, and that can live with a child for the rest of their life.
Yes. So we put this there. If you can take a screenshot when you're making your application and you don't meet the financial requirement. This is a respected document. The authors are known. They're very respected lawyers and academicians, and some of them are social workers who practice for decades. And look at where these reports are coming from. We could read the
schools and teachers were cited as a key source of support, stability, and consistency in children's lives, and will be an area of focus for the next stage of our project. It was felt that often schools didn't understand the situation, and extra support would be valuable to raise awareness about these rules and how they impact children and families.
Yes. So I did say that in 2017, the Supreme Court said it didn't breach Article 8, and it didn't create discrimination, and it didn't prevent integration. It rather encouraged integration. But this report says that it creates discrimination unnecessary against people who are living outside the Southeast, especially outside London, against women, against other nationalities, and children who have been separated from their other parent were going through some of the most horrendous behavioral impact that you can ever imagine. I mean, somebody who is self-mutilating means that they are cutting themselves, self-harm, suicidal ideation. This is the most critical issue that we all have to look at, because if your child comes to you and it tells you they have suicidal thoughts, Kweku, it's frightening.
It's frightening.
Yes.
It's frightening. You find it very even difficult leaving their site or leaving them alone, because you don't know what will happen the next moment. So, what has been the impact of this document, Akaben? I'm scared, and I'm getting short of words, that if this is from 92% of people surveyed, then it's real.
Yeah.
And you mentioned that if it is not Article 8, then we don't know what it is.
Yeah.
What has been the impact? Has it really affected or improved the chances of people who do not meet those requirements?
So this document is 2 months old. Let's go to the top of the document.
Okay.
Yes. It was published in December 2023. So it's only 2 months old. And we intentionally brought it. I've just shared with my team. We obviously use it in our office in Ghana a lot. And we cite a lot of, because it's a respected report. If you go down to page 2, look at the people who are on the board. Colin Yo is a respected immigration barrister. Children's Legal Center, they do research about children. Professor Eleonora Kaufman, Professor of Gender, Migration and Citizenship. Fiona Jeffrey, OBE, Chair of British in Europe. Professor Helena Ray, Professor of Migration Law of Exeter University. Ian Robertson, partner. These are respected people in the community. Young Minds is, an NGO or a charity that really looks after children who are going through mental health issues. So it's not a couple together, friends at a pub who's come together that let's write something. These are well-respected people in our community. And if they've written a report, it's a report that you can use to support any application that you make.
If you just joined us, you're live with us on the Community and the Law, and our guest and resource person is a senior partner of BWF Solicitors, Mr. Bernardo Wusu, Uncle Ben will call him, and he's taking us through the visa and the financial requirements for applications, and is taking us through the various strands of incomes and the requirements we need to meet. We have also looked at the situation where if you don't meet the 18,600, you can cite this very fresh document and use that to support your application and appeal to do that. And you can't get this from anywhere else but from BWF Solicitors. Call them now, 0208-493-7340. The Ghana number is 0023355595959, and the emergency number is 0044-7712-761884. The numbers are on the screen as we speak now. The lines are going to be activated. I've got a lot of comments on the comments page, both on YouTube and Facebook, with putting a lot of questions and comments. We'll be going through that. But before that, we want to say thank you to BWF Solicitors once again. When we come, I will again reiterate the question: what are the exemptions, and how do we manage the exemptions so we can make our applications and do them successfully? But in any case, if you can't do anything, whatever it is, speak to BWF Solicitors. We'll take their message and we'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates, often with inheritance cross-border issues, international trust advice, including residence, domicile issues, wealth preservation, A fast, efficient service from SRA-regulated professionals. Transparent pricing. BWF Solicitors. Let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Okay, welcome back, and thank you very much for sticking with us. We're live on BWTV and live on BWF Solicitors Facebook, YouTube, and all the other social media platforms. So if you have not shared the link, please do now, because as I said, I'm going to give you some statistics this afternoon to show that people are sharing, and we'll find out who is in the lead to win the Senior Partner Appreciation Prize when it comes to December 2024. We are discussing financial requirements and some exemptions to that, and Uncle Ben is being gracious to take us through some of these things. But I want to reiterate, Uncle Ben, what are the exemptions?
So the exemptions are two. There are passported benefits that will take you out of the 18,000 requirement, but you still have to show adequacy of maintenance. And then there are those who, because of the case of Lebanon and because of GEN 1.3 and because of the report we've shared, there are particular circumstances in their lives which means that if they are told that because they haven't met the income requirement, they cannot join their spouse, it will breach Article 8 and also Section 55 of the Borders Act, which means that the Secretary of State must take the interest of every child in consideration whenever they come to make decisions. So the benefits that we always mention are benefits that relates to injury, disability, and disability remain mental health issues, physical disability, emotional disability, any disability that qualifies you to claim certain types of benefit, disability living allowance, disablement allowance, widow's injury pension, certain types of injury compensation from the police and from the army. And then we have the old style industrial injuries compensation payments. All those will passport you. So it takes you away from the 18.6 and that will continue even after the 11th of April.
Okay.
The benefits, before we confuse this, the benefits which do not count are what's it called? Child benefit, housing benefit, council tax benefit, all those other benefits that people claim, which is not related to injury or early pension because of injury or disability. Those benefits will not qualify you. What will also qualify you is what we called the General Exemptions 3.5. And I put a lot of emphasis on particular circumstance in the family's life, which means that either the mother cannot go and work or the father cannot go and work, because we always say mothers, but also sometimes it's a single father who's looking after the child who cannot go and work. So the example will be people who are unable to work full time because they have childcare facility. They do not have childcare facilities, and there's a young child involved, and they can provide evidence that leaving the child to work full time creates this particular problems, and also the report that we've mentioned. You can use that to support your Section 55 application. The Home Office accepts that these two exemptions will allow you to come here, but they will put you under the 10-year route instead of the 5-year route.
Oh, okay. Well, 0208-493-7345. You can send a text 07399208-468 and send a WhatsApp message, audio notes on 0795042270. There are a few of them on the platform which I'm going to pick up. But let me also take this opportunity to acknowledge a few people who are on there. Because of time, I may not be able to go through the whole list, but we have a duo to Safi, Sibaji Sahu, My Sea Blessings. We have a Odro, Simonohine Amwako, Benjamin K. Menu, and that 0208-493-7345. Hello.
Oh, hello. Good afternoon.
Good afternoon. How are you?
I'm fine. But the person will take you.
Okay. I'll try and do the translation as well, because we have a lot of people who do not understand the tree language. But please go on.
My friend, I'm a dawate. Now, Coco Shell. I'm a da and convent track at the opening Yanko Shell.
Amen.
Or do my baby out with me. Ediabana, whatever my update in on the law. It's where they ask the guy and I'm benam. Pancho Ben, Pacho, my send will be on WhatsApp. In Pacho, Conacutina,
WhatsApp or not number?
I will make me WhatsApp, make the amount of Ben.
Oh, so you sent it directly to his phone?
Please, yes.
What's your name again?
My name is Francesca. Uncle Ben knows me.
Francesca. Okay. All right. All right. Thank you, Francesca.
Okay, thank you. Bye.
Bye. Francesca called in to say thank you to BWF Solicitors, to Uncle Ben, and to us on the TV program for coming your way every weekend to give the various updates. And she said she sent something to Uncle Ben's phone. She's expecting an answer for that. We'll look at that later on. Hello.
Hello.
Good afternoon.
Good afternoon, bosses. Good afternoon, Uncle Ben.
Good afternoon, boss.
Good afternoon, BW.
Good afternoon.
Hi. Just a quick one, Uncle Ben, if you may help me. Let's say I'm an European citizen. I came here before we went out of the EU. But I had an appointment with the HMRC for my NI. But due to one or two, I couldn't go for the interview. And I went back. Now, I've made my mind to come back and live in the UK. Can I use that appointment letter as one of the proof that I was here before we came out of the EU, and then apply for the NI and continue to get my resettled, or I cannot?
Well, the two main challenges that you face. The first challenge is that you have to show that you were here by the 30th of December 2020, and you also have to show why you haven't made an application as at August last year. So those are the two challenges that you have to face. The first one is purely by application. The second one is by explanation. I can tell you that the Home Office has been very naughty recently, and I think we need to crank up our judicial review, which we're doing. So yes, it's doable. You can do it. Okay.
Oh, okay, it's doable. Okay.
Yes.
Yeah. Congratulations to my girl. What's the name?
Deborah.
Deborah.
Deborah. Yes.
Yes.
Say Kofi Antubam can congrats her.
I'll tell her. I'll tell her.
Congratulations. Thank you very much.
Okay then. Bye bye.
Okay. Well, 0208493735, 0208493735, or send your WhatsApp message on 07950422780. Benjamin says, good evening, Uncle Ben. Please, what is the income requirement if you have an indefinite leave to remain and want to sponsor your spouse from abroad? I think probably that's what it is. Yeah.
Yes. So the income requirement is that before the 11th of April, if you're making an application, you must be earning 18,600, either from employment, self-employment, or on a non-employment income. From your savings, you have to tot up and add 16,000, multiply the whatever savings you have by 2.5 years. If you're relying on employed income, there are two types of employed income: salaried income and non-salaried. Salaried is the one that is constant. The non-salaried is the one that goes up. Those people who like doing a lot of overtime. They are all called employed income. You need 6 months pay slips, 6 months bank statement, last P60, employer's letter. You have to make sure that your bank statement matches with the pay slips. And you need a pay slip for the last 6 months before the application. So the month in which you're making the application, it should be the preceding month back. Preceding means the one before that month, back 6 months. So if you're applying in March, no, we're not talking about March pay slip, we're talking about February going back.
All right. Well, let's pick another comment from the platform. Good morning, family. Please, be on behalf of a friend. He is an EU indefinite to remain, married since 2018, but a wife joined him in 2020 and the marriage is broken down irretrievably. He had one child with her, but divorce wasn't done. He recently met a lady in Ghana that he wants to marry. He wants to know if the new fee is going to affect him since he's an EU national. Can he bring the new wife 4 months after the divorce? And can it affect the ex-wife when applying for indefinite?
No, it will not affect the ex-wife, as obviously she will have what we call retention of right. They've been married for more than 3 years. They've lived in England for more than 1 year, so that will not affect her. If you're bringing your wife, the wife became a family member of an EU national after the 31st of December, and therefore they come under the immigration rules, and yes, the income will affect her.
0208493735. We've got the voice note here, which we're going to pick up. Let's see.
Okay, good afternoon. The same for Ghana, but we will all kinds of benefits there you can think of. The same from 1st of May, now for my 1st of June, which will affect me benefit in Ghana. That's it.
Well, okay, Ben. She's on benefits and she wants to travel to Ghana, and she's trying to find out if that's going to affect anything, her traveling and all the other bits.
No. I mean, she's not going for more than 6 months, so that shouldn't affect her. She's only going for a month.
A month, yeah.
Yeah, she's okay. She can go.
All right.
Yeah.
Well, let's pick up some comments from the platform as well. Ricky says, can you please send me the requirements if you want a spousal visa? Ricky, okay. If you could send us, send your request to our WhatsApp number 07950422780 and respond to that. Well, But maybe we can quickly pick up that. What will be the requirements?
Well, the requirement for a spousal visa are three broad requirements. So we have the eligibility requirement, we have the suitability requirement, and also we have the partners requirement. So on your partners behalf, they have to be either settled here or British citizen or refugees or in the army. I think somehow it falls under the eligibility requirement as well. You need to show that you've met a person, either you're married or you've been in a durable relationship for 2 years, or the person is your fiance, so they're coming for 6 months to come and marry. You also need to show there's accommodation, so we call it adequacy of accommodation. And then you also have to show that you have the maintenance, in this case, the 18.6. It's not the adequacy of maintenance, the adequacy of accommodation, but the maintenance refers to the 18.6. Now that is going up to 29,000 on the 11th of April. So anyone that wants to bring their partner, they must act now, because not many people earn 29,000. And clearly, if you don't earn that money, then you will not be able to bring the person. But if you apply before the 11th of April, and even if a decision is not made, you will be covered by the old rules, which is 18.6.
Next comment, let's see what question there is. What's currently the wait time for spouse visa standard application? That's from Junior.
So the spousal application for standard outside the UK, you're looking at 12 weeks. In the UK, again, you're looking at 12 weeks. Now, what I've realized is happening in the UK is that when you make your application and you take your biometric, they email the lawyer to say your application will be completed before or by this date. And usually it's completed before that date. And at the moment, we're getting applications done within 4 weeks and 12 weeks. But some applications can take as long as 6 months. If you're applying under Appendix FM using FLRP, FP, there is no service standard, and it can take a year. Clearly, it's very, very unhelpful, but it's what it is.
Okay, so let's go and pick one from, I think, Theophilus. We have a comment from Theophilus. Let's see. Good morning, lawyer. Please, I will get my, good afternoon, anyway. I'll get my 5-year in next year, March. When should I start the application for indefinite leave? Is it early before the 5 years or after?
Okay, so you know we did a somersault contortion advice. I gave you some clue to cheat a bit. That one for people who are extending. If you're applying for indefinite leave, you're racing to those who race, what did they race?
They race to the finishing line.
The finishing line.
The checkered flag, if it's
that's correct. So in Formula One, is a checkered flag, and a sprint
is a finishing
is a finish line. So for those people who are sprinting towards indefinite leave, it's a finishing line. So it's not, you're not doing relay. Relay, you can cheat. That's why relay, you see some people meet them in the middle of the way before they run again.
Some run less than 100 meters, some run more than 100 meters.
Absolutely. So what I taught you, or we shared before, I think a couple of months ago, to make sure that you're not caught by the increase in the immigration health surcharge, doesn't apply here. If you're waiting for indefinite leave, it's the time that takes you to the finish line. So that one, you have to wait 28 days before the 5 years.
Okay. We're still taking your comments, your questions and concerns. Uncle Ben is here to help us do that. But remember, if you need any immigration advice, any legal advice in the community to help you make your applications, filing your appeals and the rest of it, talk to BWF Solicitor 0208 493 7340 or 077-127-61884. Let's see what next we have. You can also call us now on the program to speak to Uncle Ben 0208 493 7345. Let's pick up the next comment. Hi, lawyer. Grace says, my humble question is, I married in 2009 and made an application to the Home Office in 2012, and I was refused. I made an appeal and was granted 5 years, 2015 January, and I got my permanent resident 2019 June. Please, can I apply for naturalization and citizenship?
Oh, yes, you can apply, because I can see that you've passed all the required milestones. You've done more than 5 years lawful residence, and then you've done more than 1 year when you got your indefinite leave to remain in 2019. So you qualify, yes.
Yes, I know you'll be smiling from that answer. 0208-493-7345. Somebody is asking Uncle Ben. Let's see what we have here. Okay, this from our WhatsApp line. Let me put it on the platform now for you to pick up. Oh. I want to bring it up on there so I can read. The person says, please, I will apply for indefinite leave soon, but I would like to know if I do not work, but my husband earns around 34,000 annually. Can I rely solely on his income?
So your husband's income is a household income, and yes, you can rely on that solely. And most people rely solely on the settled partner's income. So yes, you can.
Okay. The person has quickly said thank you. Thank you also for sticking around. BWF solicitors. Now, I mentioned that we are asking you to help us make our algorithm look good and bright. And we are asking you to share the page and also ask people to join us. Now, last year, Tilly Duma won the Senior Partner Appreciation Reward, and that wonderful weekend she enjoyed. I know if I had my own way, I would have taken it away from her. But yeah, you know what? That's for you doing what we ask you to do. Now, this afternoon, I'm going to show you the algorithm that shows us who has shared most from the past 2 to 4 weeks. In fact, 2 to 8 weeks, I should say. Tilly Duma is leading with 412 points over a 2-week streak. Margaret Dumensa, 406 points over an 8-week streak. 259 points. Ademonunkum over an 8-week streak. Kenneth Ofori Boateng, I think that's our Antubam, 226 points. Theophilus Forson, 163 points. Lauren Miswa Peku, 159 points. Joseph Isaiah, 92 points. Emmanuel Nana Kwame Ampiao, 90 points. And Dokas Adom, we have 83 points. So keep it coming, keep it going, share the page, engage the platform so we can show our position to you at the end of the year. So Tilly, I know you would want to still set the record and lead the pack, but I am daring people to challenge you to all that. Before we pick up any other comments, let me go back to our nugget and take a break, because we'll be having our quiz segment on that one as well. Care and senior care workers on SOC 6145 and 6146 can still bring their dependent family members to the UK after the 10th of March 2024 if they are already in the UK or have applied under the route for leave by the 10th of March 2024. Statement of Changes in Immigration Rules HCE 556 dated the 19th of February 2024. We're here courtesy BWF Solicitors. We'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208-493-7340 or our emergency line 07712-761-884.
Or something, yeah. 0208-493-7340, live on BW TV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We have been discussing spouse visa financial requirements and exceptions and how to meet those requirements. Let's go to the phone first. Hello.
Hello.
Yes, good afternoon, sir.
Good afternoon, sir.
Yes, go ahead, let's hear you.
Yeah, but I'm person may inquiry kakra.
But you too.
Okay. The patch may enemy ma okuma say. But first na me dependent to my wife because my wife is skilled worker but has a carer. Yeah. But you see my joining the UK Armed Forces. So for now my person can my wife enemy man a bed dependent because my wife will pursue wishing to know like only that independent or education person between but before which I join them. Unless with me in you see that US now no use no enjoy education. The person who acquire with my first one. And I'd right here with my boy because person dependent for now.
Okay. So his wife had a COS and he and the children were dependent on the wife. Now he has joined the army and he wants to turn the bottle round so the wife and the children will become his dependents. How is he going to go about that?
Well, it's very easy. Very, very easy. So he will have to use the army route, meet the financial requirement. They're already married. They're known in the system, both the wife and the child. He needs an income of 18.6. If there's a child, it's 3.8 for this first child. If there's another child, it's 2.4, and you add up. He will be earning more than that I know. So he should just switch immediately. Right. Because any day that he leaves it takes longer to reach the 5 years.
Right. So don't waste time. And I would advise that if you have any challenges, just come over to BWF Solicitors or call and book an appointment. They'll help you with that. We have a comment from Ajua that says that I'm married to an EU national and I have a daughter who depends on my husband who happens to be his stepchild. And my husband has got indefinite leave now. So can my child apply for indefinite leave?
Well, if you and your child are dependent on the EU national. The EU requirement says that where there's a child of the relationship, because your child is also deemed as a EU national's child, they are not called stepchildren under EU law. They are called their family member. The family member can apply. I've seen some pre-action protocol that they've responded to, and they are all over the place with this. Some of them, they are refusing it because they say it has to be a direct family member. Of course, it doesn't say that. So you can apply for indefinite for the child, yes.
Okay. Let's go to the phone line 0208-493-7345. Hello.
Hello, good evening.
Good evening.
Good evening. A big advice I need from Uncle Ben.
Yes, please go ahead and ask.
Uncle Ben, I'm a student. I came here with my missus. And my missus has gone out of the wedlock to have an affair with somebody else. And now she's pregnant, and she's admitted that she's pregnant with somebody who's a British citizen. In this case, who is going to be the father of this child? It's going to be me or the British father who had impregnated my missus. If you can advise me what to do and what will help me in the future. Thank you.
Okay. Uncle Ben.
Yeah, it's very sad, isn't it?
Yeah, it's quite unfortunate. Uncle Ben, just hold on.
Yeah, it's really sad. I mean, first of all, so what we have to look at is the law. What does the law say? Well, we know biologically the child will be the child of the British citizen, biologically. But legally, when you look at Section 59A of the British Nationality Act, it says that the father of a child is the husband of the mother at the date that the child was born. So the father will be the student. But if they get a DNA, right, and the DNA proves that as a father is a British citizen, then the child becomes British citizen. They can register as a British citizen, and they will use a free form called UKF, and then they can apply. So for now, if the woman gives birth and she's still married to you, the child will be your child.
Okay. 0208-493-7340. Let's see this voice note.
Good evening. Bonjour. I'm sure on YouTube. Masamne mapelanka wopomna meni power mepeda me warwala na yakaya mama ina ofwali customary marriage. Now with the certificate in what I send or how UK. Many percent so na YouTube na yada where na it's like you however because na it is the benefit say it's good to ma obakara ko kana na zinzi oya and then youth meaning na often no YouTube na me when videos people work at the master no the obetum na why ebusun we share no certificate in it what the Ministry of Foreign Affairs what I sent our cost of marriage now we to me what I file application. Let me so please send me that number contact on that to them. So betum ne feel more upon what I'm going to na I call them me bo. I call them me bon na for an application na IMS no so them to meet you na someone so better no I mean na you kona pede mafada mubutu ne mama pede anka ever start number dot ne de ami benino ami no menketa nkata me no me ba asesi man nti no you contact paper na de ye de be but maybe no meeting can cross Scotland asana me ba be shemu me for England but beside me be the mazo no we say we Italian passport na fi so okite owo aha indefinite oson so oye adwuma nti I mean situation and I mean not nti me did tuni me say kono akwembe wo go tumne fi de wole bobo ma na me hona tempe ma hwe na me tu no na ma me don't ask.
Well, Uncle, this one is from somebody who has met a lady who's an EU national and has got indefinite here in the UK, and they want to get married, but they want the marriage ceremony to happen in Ghana. The two families will meet, and then they will give them the evidence and put that in for their application. He does not have a status, if I should say so, but the wife is an EU national and has got her indefinite here in the UK. Is that possible? He's asking how much he is going to pay for the IHS and also how much the application fee will be. And obviously asking about the services of BWF services, how it's going to cost him.
Yes. So I also heard, I know he spoke in Fante. I also heard that he said that he doesn't have any status.
Yeah.
So there are a lot of questions that we need to ask, but I will answer the question as if I didn't hear that he hasn't got any status. Yes, we actually encourage our own to marry under customary law, which means that the marriage can be done in Ghana and sent to you. It has to be done properly. It has to then be registered because you're not going to show the video of the marriage. You're going to show the marriage certificate. And therefore, it has to be done properly. It has to be certified by the Ministry of Foreign Affairs and Regional Integration, by the High Court and the Superior Court. And then we also advise that once it's come here, you take it to the Ghana High Commission for them to also certify that. The Ghanaian marriages are recognized under British law. So if it's done in Ghana, people call it proxy marriages. Whether it's proxy or whatever it's called, it's a customary marriage and it's valid in Ghana, it's valid here, he can do it. So that's possible. But the other bit of not having anything, he needs to show that there are insurmountable obstacles or there's a child in the relationship, either his child or his stepchild, and then he can use either an EX1 or EX2. Both will hold him, it will be helpful. The fee, the IHS fee is about 2,655. The application itself, it's about 1,048. When you combine, it's over 3,000, let's say about 3,700 thereabout. Our fee varies on the based on the complexity of the case. So once we know what his status is, what evidence he has, what we need to help him with, then we will be able to tell what our fee will be. But we are not very expensive. We are reasonable.
Okay. So, yeah, visit BWF solicitors and listen, that's the surest way and that's the best way to go. So call them 0208-493-7340 and you can find them on the 4th floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters, North London. They work Monday to Fridays between 9:30 in the morning and 6 p.m. in the evening. And if you want to meet them over the weekend, it's by appointment only. BWF solicitors are trusted partners when it comes to the law. Let's take another comment quickly. My question is, I want to bring my girlfriend from Ghana, but I cannot meet the financial requirement of £29,000. Can I use my savings to meet the financial requirement? Taribu is asking.
Yes, Taribu, you can. But you said your girlfriend, and I assume that is a girlfriend that you've dated for at least 2 years, because we know the definition of partner under paragraph 6 of the immigration rules includes someone that you've been in a relationship with for at least 2 years before the application. You need to show the evidence. Yesterday, Asma spoke about it. He was able to identify what the relevance of some of the evidence will be. Usually will be evidence of contact. So you need to show that you've met this person before. Usually will be photographs and travel to Ghana, stamps in your passport, WhatsApp communication, WhatsApp video, text messages, phone calls. The financial requirement, let's for argument's sake assume that you're earning 15,000 a year. So you're short by 3,600. You have to add your savings. The starting position for your savings is that you have to start with the 16,000 first. before you even talk about a shortfall. And then the shortfall is 3,600. You multiply 3,600 by 2.5 years, which is what the visa they're going to give her. The 3,000, today, my maths here, so 3,600 times 2 is 7,200.
Yeah.
If you add 1,500 plus 300 is 1,800 to 72.
That is
9,000. No, so what then? So that gives you 9,000 plus 16,000. That would be 25,000. And then let's say you're earning 15,000. You've got a savings of 25,000. You've got it. That's it. Yeah.
So Taiwo, you don't really have a big issue. So if you are in doubt and you have any challenges, contact BWF Solicitors and they will help you. Let's pick up another one. This one says that my kids are dependent on my wife's leave it there. My kids are dependent on my wife's skilled worker visa for a year now. I'd like to know if my wife and children can switch their visas to mine as dependent.
Yes, they can switch. Yes.
Okay. Well, let me pick the nugget again, because after that, I'm going to put the question on, take a quick break, and then I will come to test your knowledge of the things we put out. Remember, Mondays, Tuesdays, and latest by Wednesdays, we bring you the nugget, the question, and other updates that will come. As for the updates, immediately they drop, BWF Solicitors put it out there. So watch out for BWF Solicitors on Facebook, YouTube, Instagram, LinkedIn, and all the social media platforms. Care and senior care workers, SOC 6145 and 6146, can bring their dependent family members to the UK after March 10, 2024, if they are already in the UK or have applied under the route for leave by March 10, 2024. This is from Statement of Changes in Immigration Rules, HC 556, dated the 19th of February 2024. Now, let me bring you the question that I'm going to ask, and you ponder over that, then I'll come back to you. Amma B, a healthcare worker with Abacus Nursing Home in the UK, has 2 children in Ghana, aged 2 and 4. Amma wants to bring her children to join her in the UK by April 2024 because of suitable accommodation. She's been told that she has to make the application before the 11th of March 2024, or else her children's application would be refused. What advice would you give Amma B? Now put yourself in the shoes of Uncle Ben and all the other lawyers, and especially very own Deborah, who is just being called to the bar, and give Amma B an advice. She has to apply by March 10, 2024, so don't face the ban. 2, she can apply anytime, even after March 10, as she is already on the care worker route. And 3, if she applies after March 11, she has to earn 38,700. This is a tricky one, isn't it? But think about it. I'll go through it again before I take my break. Amma B, a healthcare worker with Abacus Nursing Home in the UK, has 2 children in Ghana, aged 2 and 4 years. Amma wants to bring her children to join her in the UK by April 2024 because of suitable accommodation. She's been told that she has to make the application before the 11th of March 2024, or else the children's application will be refused. What advice would you give Amma B from what we have learned last week, this week, and even now? She has to apply by March 10, 2024, so they don't face the ban.
Yeah.
She can apply anytime, even after March 10, as she is already on the care worker route.
I'll mention it
Then if she applies after March 11, she has to earn 38,700. You know what? I'm going to take a break, but I have something as a bonus, and I would put that to Uncle Ben quickly, and so that he can give us a clue on that. There's an article that he's written, and we're going to have that posted. Then I will signpost you to where you can find the article. If I could have the article on the screen, that would be brilliant. Healthcare / senior care workers already on the route can still bring their dependents after March 2024. Wow. That's on the
website
bwfsolicitors.com. www.bwfsolicitors.com. And come on, a little insight on this one.
Yeah, so what I've done, Kweku, is because it's caused initial problems, I wanted to help the lawyers in the community and also help our community members.
Right.
So the video, not everybody watches it. Flyers, not everybody sees it. But we've also got a website. So I said I'll write an article. The article is soft and hard. The hard part is for lawyers and the soft part is for everyone. So when you read this article, it's very short to read. I think it's about 3 minutes read. It will tell you what has to be done. And there are other articles there. And you can even quote this article if you want, because if you go up, down slightly, there are hyperlinks to the article, which will take you straight to the law. So go down. Yes. So those colored one, if you click on any of them, Adai. Yeah. So that's what we've done. And
this is the document we read last time.
This is a dangerous document. And then after you can click the other one as well. Any of the other ones, yes. So this is what I've done. I mean, there are things that I mentioned, people don't know what they are. This is what click the last one as well, and it takes you. So it's a lot of work, but I tried to do it for the community because some people like to read it themselves, and this is what we've done. The article is there, the hyperlinks is there. Lawyers can use it, non-lawyers can use it. It benefits the community.
Well, I'm going to take that quick break, as I said. If I were you, I would quickly go to bwfsolicitors.com, www.bwfsolicitors.com. You'll get the answer there. But in the meantime, let's pay our dues. We'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208-493-7340 or our emergency line 07712-761-884.
Yes, and we're still on. I can see that people are participating and sending their answers on there. So let's pick the question again, and we'll look at that. If anybody can really dare, you can come on the line and tell me what your explanation will be for whatever answer you choose. The question is this. Amabi, a healthcare worker with Abacus Nursing Home in the UK, has 2 children in Ghana, aged 2 and 4. Amma wants to bring her children to join her in the UK by April 2024 because of suitable accommodation. She's been told that she has to make the application before March 11, 2024, or else her children's application will be refused. I'm asking, what advice would you give to Amabi? 1, she has to apply by March 10, 2024, so they don't face the ban. 2, she can apply anytime after March 10 as she is already on the care worker route. Or 3, if she applies after March 11, she has to earn 38,700. Has somebody gotten any? Yeah, let's see. Kenneth Furibuating Antubam says number 2, She can apply anytime, even after March 10, as she is already on the care worker route. Santiago Munez. Number 2, same answer. She can apply anytime, even after March 10, as she is on that route. Ama Diana. Same answer. Number 2, she can apply anytime, even after March 10, as she's already on the route. Rebecca Amuako. Number 2 seems to be very popular. Rebecca Amuako, number 2, she can apply anytime, even after March 10. Kevin Asamoah also says number 2. Who else? Lydia B also says number 2. Okay, Robert Jemfi, number 2. I think, Robert, you answered earlier on in the week when it was put on social media. Justice Akwa, you also answered earlier on when it was put on social media, number 2. Your own team says number 2. Okay, yeah, people are doing their research, aren't they? Abigail Osemensa says number 2. She can apply anytime, even after March 10, as she is already on the care worker route. Emmanuel Boachi also says number 2. So far, I haven't had any answer apart from number 2. So, Padmore Esinugbevo says number 2. Okay, Angaben, number 2 seems to be very popular. Are they right?
Well, let's see. What does the nugget say? If we go back to the nugget, it tells us what the law is. We know that HC, which is a statement of changes in immigration rules, was published on the 17th of February. And it says that certain things are going to happen on March 11th. But, what was going to happen is that they were going to ban care workers from bringing their family members. But then they went on to say that, however, and they use the word unless, which is a conjunctive word, and it means that there will be exceptions if you're already on the route. So when we say you're on the route, it means what started? You're already there. It's either you're there physically there, or you're there, your application is in there.
Pending a decision.
It means that the transitional provision protects you. And if that is the case, then let's go to the question. Ama B, this name Ama B, there's another one called Ama Diana. So I don't know whether they are sisters, but maybe. Ama B, a health care worker with Abacus Nursing Home in the UK, has 2 children in Ghana, aged 2 and 4 years old. Ama wants to bring her children to join her in the UK by April because of suitable accommodation. And you have that a lot. People haven't got the accommodation, they can't afford it. They've planned ahead, they've been offered accommodation. It will start sometime in June or thereabout. She's been told that she has to make the application before March 11th, 2024, or else the children's application will be refused. Well, is that right? I think the answer will be number 2. She can apply anytime, even after March 10th, because she will be protected by the transitional provision. The law has been published. It was published on the 17th of February. They're not going to change the law. It's already law. Just that the start has been delayed, and therefore the answer is 2. I think there's a reason why. I don't know whether. Yes. So this is why. So when you read my article, you will see this. It's a new SW 29.1A. And this is why they can bring their child. And then there's a new SW 3.1. This is 5.1, SW 29.1A, and then SW 3.1 for husbands and partners. So the answer is 2. And I think that we know that the community has learned something. For us, this is to share knowledge. It's not just to put things out there. And it's not just to tell people that, we exist. It's to say to our people that there's information that we share. And this is the information. If you follow the information, it will help you. The number of people who have followed the information and done this themselves, it's amazing. And that is why we always do this. Monday, Tuesday, every day of the week, we're working. So, Kweku, number 2, I think that we should applaud all of them.
Yes, everybody that's answered number 2, well done. Thank you so very much. And thank you for paying attention. You would appreciate that when it's dropped, the nugget is dropped on Monday. Later on in the week, the question is dropped. On the social media platforms, people try to answer. But when we come on the program, we give you the explanation expanded so you clear all the doubts in your mind. But if you are in doubt and you want to have any clarification, or you want to send your application or get your support for any application, please call BWF Solicitors on 0208 493 7340, 0208 493 7340, or 077 127 61884. Now, tradition demands that we round up and draw the curtains down. So I'm going to the desk of BWF Solicitor Senior Partners Office and to ask him to give us a brief summary of what we have discussed this afternoon. Spouse visa financial requirements and exemptions.
So, well, thank you all for joining us. It's always a pleasure to serve you. The reason why we focus on this subject is because of what is happening on the 11th of April. So from the 11th of April, if you're not earning 29,000, you will not be able to bring your partner unless the two exemptions that we talked about applies. So first of all, between now and the 10th of April, between now and the 10th of April, if you're earning 18,600, you can bring your wife, your husband. If you want to add a child, it's 3,800 for the first child. The second child is 3,400. The sources of income, we've given you A, B, C, D, E, F, G, and H. Now, the A, B is income which is earned from employment. The C is income otherwise from employed. So that would be your debentures, shares from real estate. And then the D is what we call the savings. The the E is what we call the pension scheme. And then we have the F and the G, which is a self-employed 1 year, self-employed combination of 2 years. If you cannot meet this requirement and there's a child or there's a particular reason or circumstance in your family life which will affect a child or you can rely on what we call GEN, which is a General Exemptions 3.1. The law, the case of Lebanon clearly says that if you haven't got a resource, the Home Office will make it possible for you to bring your partner if there are particular challenging circumstances. Home Office has created a catch-all phrase, which is a GEN 3.1. In addition, there are certain people who have been passported, people who are receiving disability living allowance, any living allowance, any disability allowance, any pension that is related to injury, industrial injury for military or for the police. Any of those ones will passport you. You just have to show adequacy of maintenance. There are other income that you're receiving, academic maintenance, for example, usually will be for nurses and other people. If you're receiving that, again, you can use it. If you're receiving alimony or maintenance payment from your husband or ex-husband, your wife or your ex-wife, again, you can use that. What you cannot use is the everyday benefits that people get, that you cannot use. To meet this requirement, you show your pay slips, you show your SA 302, which is the Inland Revenue document, your employer's letter, 6 months bank statement, your last P60. Above all, we wish you that when you're making this application, you put all this together and write a letter to explain whether it's self-employed, earned income, or income from investment. It's always good to explain that. Thank you very much.
And with that, we come to the end of the whole story this afternoon. It's been a very pleasant journey, 2 hours of the precious time of the senior panel, BWF Solicitors. Want to say thank you, and thank you again. And to you out there who have stayed and listened, participated, asked questions, and also shared the link, we want to say thank you very much. So on behalf of everybody at BWF Solicitors, everybody at the offices here in the UK, offices back home in Ghana, in Accra, so to speak, and on behalf of my studio producer, Professor Ade, Sheila Ankra, and Pat Modudu for the admin and aesthetics work, and to you out there, I say, have a good evening, and welcome to the month of March. To our Muslim brothers and sisters who are going to start your fasting, I wish you all the very best. Let's go through this journey and get the blessings of Allah. And to our Christians who are also in Lent and waiting for Easter, Let's go through this journey and get the blessings of Christ Jesus, our Savior. My name is Oreku Sifripon. Have a good evening.